Okay, we are back. Hopefully you had your coffee. And it is my absolute pleasure to introduce two of the attorneys that I'm sitting here with at Frier Levitt. And first I want to introduce Dan Frier. He is a co-founder of Frier and Levitt and has been here since 2000. He has practiced exclusively in the healthcare law since graduating from Temple Law School. I can go on and on about Dan. He represents so many physicians, medical practices, groups, surgery centers, and he will do whatever he needs to do to make sure that his clients are taken care of. Ambulatory surgical centers and other laboratories, healthcare, anything even involving high T. This is the practice that you want to turn to. Secondly, we're so excited to introduce Michelle Greenberg. She's also a partner at Frier Levitt, and Michelle's litigation experience is outstanding. The personal injury matters is something that she takes a lot of pride in and has been very successful for her clients that result in money judgments, injunctive relief, and dismissal of the frivolous lawsuits. So the bios you'll be able to read later. And without further ado, we're going to turn over dealing with problem physicians in an ambulatory surgery center. If you do have some questions and you want to put them in the chat, we'll try to get to them. Thanks so much.
Thank you, Marcy. Today's topic, there are many topics I could have spoken about today, but I decided to focus on the topic that I think actually probably creates the greatest difficulty with most of our surgery centers. You know, surgery centers nowadays are dealing with a lot of issues: competition, you know, payer contracting and reimbursement issues, audits, government investigations, malpractice cases. I think from my perspective, and I haven't done a deep dive in terms of the data on this, but from my perspective, we probably deal more frequently with problem physicians in an ASC setting than any other issue. And what I'm going to do today is, if I can advance my slides, which I can't do, here we go, good, is I'm going to go through some of the legal challenges, some of the business challenges, and hopefully some of the solutions on how to deal with these issues today. The main issue with dealing with problem physicians is, first of all, defining what a problem physician is. And a problem physician is someone who has behavioral issues or someone who is not holding their weight, carrying their weight with respect to volume. And we'll talk about both those issues. From the perspective of the second issue, carrying one's weight in terms of volume, that presents all sorts of legal challenges that I've dealt with many, many times in many different ways over the years. You know, for example, you have a very busy, high volume surgeon who approaches management and says, you know, I'm tired of getting such a small distribution because we're giving distributions out to surgeons who aren't carrying their own weight because we have to give distributions based upon ownership. So let's just talk a little bit about the legal frontier. Most of you are somewhat familiar with the Anti-Kickback Statute and the applicable Safe Harbor. So the Anti-Kickback Statute prohibits physicians from receiving any form of remuneration in exchange for referrals. And early in my practice, before the ASC Safe Harbor, there was no protection for physician-owned surgery centers. There was some guidance that the OIG had out in the form of an advisory opinion. But then, you know, going back, I don't know, 15, 20 years, the ASC Safe Harbor was developed. And essentially, as most of you understand, that Safe Harbor, it's fairly complex. But a couple of the key components are that the referring physicians, who are also owners of the center, have to receive profit distributions that are based upon their ownership. They can't obviously receive a profit based upon their referrals. And even choosing physicians, even offering an interest to a physician cannot be based upon ownership. So for example, it may be a technical violation to offer a surgeon a greater interest because you suspect that their volume is going to be greater. And yet every surgery center is a business that depends upon referrals by the surgeons. So how do you structure a business ignoring who's going to be bringing what. And the reality is, the law is not entirely clear on what you can do in terms of choosing physicians at the start of the relationship. But certainly, as we'll talk about more later, getting the right people on the bus at the very beginning is the absolute best way to protect yourself from this particular issue. So the ASC Safe Harbor affects the syndication or the initial offering for an ASC. It affects terminating surgeons. We've had situations, for example, where we've represented a center that decided to terminate a group of doctors because they were essentially bringing in very low volume cases, very low value cases, and the cost of the equipment associated with supporting those surgeons was considerable, and the center just didn't want to invest the money in that infrastructure, that equipment, if ultimately they were not going to generate a return. So we found a way to terminate. The surgeons sued, and they ultimately lost the case because of the way we handled it and managed that process. There are also, in addition to the anti-kickback statute, many states have their own version of the anti-kickback statute. And what I've found is that most states, when they do have that law, the law is much broader. First of all, federal law only applies to federal payers like Medicare, Medicaid, or TRICARE, whereas state law applies to all payers. And often, in addition, state law can be less concrete, less clear, fewer exceptions. A lot of people also say to me, well, the anti-kickback statute has this ASC Safe Harbor, and as everyone knows, safe harbors don't have to be, you don't have to meet a safe harbor in order to comply with the law. And there's truth to that. However, as I tell my clients, there are some safe harbors that are more requirements that are more important than other safe harbor requirements. And in some instances, I would say that it would be foolish not to comply with that safe harbor. For example, most of you may be somewhat familiar with the 1/3 requirement. There's several 1/3 requirements, but one of them is that a surgeon, in order to essentially be defined as a surgeon, has to generate 1/3 of their income for surgical procedures from procedures that can be done in an ambulatory surgery center or out of surgery, procedures that can be that constitute surgery. So that would avoid a situation where you have an internist who does some very limited procedure, and generates 5% of their income from that. That requirement would prevent them from being considered a surgeon who could qualify to own a surgery center. Well, if someone's off by a few patients or by a few dollars of that 1/3, I don't think anyone's getting into trouble going to jail for that. But if the surgery center pays doctors specifically for based upon the referrals that they send, that requirement, I think, would be taken very seriously, and I think could result in potentially severe penalties, even criminal penalties. So not all safe harbor requirements are equal, and not all of them are simply voluntary. There are also accreditation standards. Any accrediting body has its own standards, some of which involve a due process that means that if you believe a physician is engaged in conduct that may not be of the highest quality, that to kick them off the staff, you have to go through a fair hearing process. There's also state insurance fraud prevention laws. So, for example, virtually every state has a statute that makes it either a crime or a violation of the law to submit a claim that is considered a false claim. If a surgery center is structured in a way that it does not comply with the various federal and state legal requirements, then every claim that's submitted by that surgery center could be considered a false claim and could be considered a violation of the state insurance fraud prevention laws. So that the state can go after a center, even if it violates only federal law, theoretically. And we find that when ASCs get into trouble for these kinds of things, it's typically the result of a whistleblower case. So when you make a decision to terminate or punish a physician in some way, shape, or form, being aware of these laws and understanding their limitations is critical to developing a strategy. So in addition to legal challenges, there are a variety of business challenges. And I mentioned before, you have a high volume surgeon who doesn't want to be part of the center anymore because he or she doesn't want to be the only person who's bringing cases and only making a tiny fraction of the income. And then another problem is, what if there's a high volume surgeon who's actually a problem physician, problem with quality? Or I've had situations where there are facilities in which a surgeon is engaged in activity or billing or coding issues, coding problems that exposes the center to liability. Or you have nursing staff that are complaining about the behavior of a particular surgeon who's very high volume. How do you deal with that situation? Is there a way to deal with it without losing that surgeon? In my experience, allowing a problem to linger like that because you're afraid of the consequences usually creates a worse problem in the future, because ultimately something comes to a head. You're ultimately forced to terminate that surgeon, and now you've got a lawsuit on your hands because you didn't nip it in the bud when you could have done so. So burying your head in the sand on these kind of issues is probably the worst thing you can do. There are ways of dealing with difficult physicians in that situation without risking losing them. Everyone knows, okay, everybody knows that ideally you'd like to have a center where the physician's ownership percentage is exactly equal to the percentage of profits that they generate from their referrals. In an ideal world, that's exactly what happened. You'd have a surgeon who, if the surgeon generated 10% of the profits, they would coincidentally have a 10% ownership interest. If you have something like that, then it doesn't matter if you have low volume surgeons, because they're getting a low percentage of the profits. The problem is you cannot obviously structure a center that way. So this is the biggest problem in a lot of centers, which is I'll call it a disparity between the percentage of business that's being referred and the percentage of ownership. And that disparity means somebody's ox is going to be gored, right? It's going to be the busy people that are referring most of the cases that are going to get a disproportionately low distribution. And this ultimately can be the death knell of a center. I actually, about a year and a half ago, I worked with a center that completely fell apart. And most of the surgeons were no longer even bringing cases because of this particular issue. So, an ounce of prevention, okay? As I said before, the best way to avoid some of these problems is to start your center out properly. And one of the ways to start your center out properly is to structure your organizational documents so that you can terminate or discipline people who are not cooperating, and you can prevent the loss of volume arising from some of these issues. So, number one, get the right people on the bus at the start of the journey. I always say when it comes to surgery centers, smaller may actually be better. I've seen centers that have 5 rooms, that have 30 physician owners, do much worse than centers with 2 rooms and maybe 7 or 8 owners. Because at the end of the day, really what we're talking about is per partner profits. What matters. It's not the total revenue, it's per partner profits, and it's making sure that people are getting what they deserve based upon their ownership. And you can do that much easier in the beginning of the relationship. So it's a lot easier to find 7 really good high volume surgeons than it is to find 30 of them. And the more people you have, the more can go wrong. Not that you can't have a large center with a lot of physicians, but in my experience, it's a lot bigger challenge to keep everyone happy if you have a lot of them. The operating agreement should track the ASC Safe Harbor. So, for example, this is something that I do with a lot of my centers. There are a variety of 1/3 requirements, and for example, 1/3 of a surgeon's cases have to be done at a particular center, which means that technically you can't have a surgeon who owns more than 3 centers to which he or she refers cases, because they would be by definition below 1/3 on at least one of those centers. So if you know that 1/3 of a surgeon's cases have to be at your particular center, number one, you need to have the tools to track that, and those tools should be set forth in the operating agreement that every year the surgeon has to provide, has to fill out an application which describes, what other centers that they own, or refer cases to, whether they own it or not, and ensure that they're referring 1/3 of their cases to the center. But that doesn't stop a situation where you have a surgeon who, yes, they're referring 1/3 of their cases, but their case volume has gone down so dramatically for one reason or another that really that 1/3 cases really don't help the center. It is reasonable to have a minimum procedure requirement, not a minimum procedure requirement for the center, but a minimum procedure requirement to ensure that every surgeon is doing enough cases, both at the surgery center and elsewhere, to maintain their level of competency. So for example, if you determine that a gastroenterologist, I'm just using hypothetical numbers, needs to do at least 100 colonoscopies a year in order to maintain their level of a reasonable level of competency, then you put that provision in either the operating agreement or in some other policy statement, then you know that at least 1/3 of those have to be done at the center. 1/3 being roughly 33, and if because they have to do 1/3 of their case at the center. So you can dictate volume to an extent through a requirement that I think is reasonable, namely, you've got to maintain your competency by doing enough of these cases on an annual basis, and you have to prove that you're doing it. And the center can get backup information to ensure that. And frankly, it makes sense because you really don't want people that are winding down their practice, doing very few cases every year, and perhaps allowing their skills to deteriorate over time. I'm going to let my partner Michelle talk a little bit about introducing and how to handle restrictive covenants and how important they are for retention and to prevent leakage of cases. So Michelle, if you don't mind taking over.
So a large part of my practice here at Frier Levitt in the healthcare department is enforcement and review of restrictive covenants, also including non-competes and non-solicitations. And as many of you likely already know, the point of a restrictive covenant is to maintain the sanctity and the profitability of practices. In this case, many of the operating agreements that we've drafted or that we've seen, in fact, almost all of them contain these types of restrictive covenants. And where my practice comes in often is when there's either a physician or a practice who is seeking to enforce or void out a non-compete. And I can tell you from experience that the courts are going to look to see what is enforceable or unenforceable about this non-compete. And in order to protect the, in this case, the centers, it's important that there's consideration of the needs of the center. A restrictive covenant by its very nature is still enforceable. There are challenges and there's legislation being proposed throughout the country. So the reasonableness and the legitimate business interests are the most critical factors when determining the enforceability of a non-compete. Non-competes have to be, as I said, there to protect legitimate interests. They have to be reasonable in scope and duration. What is the radius that we're considering here? And what is the time frame by which a physician member cannot compete or cannot get ownership in another center?
Michelle, do you mind if I just ask you a question?
Sure.
Is there a difference between a center that seeks to limit the ability of its members from owning another center versus a typical non-compete that would be in a medical practice relationship where you're telling a physician you can't practice medicine within a certain radius?
Absolutely. So in a surgery center, generally the non-compete is to prevent ownership of a competing practice, another ASC, a hospital-based practice, whereas in a medical practice, generally the non-competes deal with physicians being limited to post-employment practice or post-ownership practice. So for example, a non-compete in a surgery center says that you can't have a financial interest or an ownership interest in another center for a period of time after you're no longer with the practice, whereas an employment or a private practice relationship, the non-compete is really more broad in saying that you can't practice medicine or sometimes practice within your specialty in a defined area and time frame. So it's definitely more restrictive in the practice area as opposed to in the ownership arena of a surgery center.
And how does that affect, in your opinion, the likelihood of enforceability?
So courts generally want to see that the non-competes are reasonable, that they're narrowly tailored, that they're not there just to prevent competition with the center that's seeking to enforce it, and that it is not something that injures the public. There's those types of considerations: reasonable in scope and time, serves a legitimate purpose, and not injurious to the public. And certainly, you know, the ability for a medical practice to essentially limit a doctor's ability to practice medicine would be much more scrutinized, I believe, than one where the surgery center is looking to limit ownership interest. However, this is where the considerations must go into play about what is it that you can argue to be protected? What is the center's legitimate interest? When you think about the scope of the radius, the area that you're seeking to prevent, what other hospitals or surgery centers are in that particular radius? Is it too encompassing? Is it not encompassing enough? These are all considerations, and they are all very factually based. No two non-competes and no two non-compete litigations are the same. Everything is extremely factual, and that's why it's important for the centers to take into consideration when they're drafting or when they're considering these types of non-competes, what will our arguments be if this is challenged or if we have to seek to enforce this in a court? What is the court going to evaluate, and how strong are our considerations?
Thanks, Michelle. I'm seeing more and more non-competes in ASC joint ventures between hospitals and physicians where the hospital will insist upon a restriction that would limit a physician owner from entering into a joint venture with a hospital outside of that particular hospital. So those kinds of restrictions, actually what we're seeing, have a very broad effect. So they could actually prevent a physician who owns a surgery center from selling their practice to a hospital, or from entering into a professional services arrangement with a hospital. The fear, but from the hospital's perspective, is that if they allow their members to enter into joint ventures with other hospitals, with competing hospitals, that competing hospital will try to pressure the surgeon from, to prevent the surgeon from continuing to send cases to that surgery center and send cases to a hospital-owned surgery center or to the hospital itself. We're seeing that more and more. I don't know about the enforceability of those things, but I think that probably will be challenged at some point. But it is a consideration for any center that has a hospital owner. Another thing I'll mention is that, you know, a center is not limited to the safe harbor requirements. The center can be more stringent. So the center can take the 1/3 requirement and say, you know, we want our surgeons to generate, you know, 50% of their revenue from surgery. You can have a more stringent and less broad definition of what constitutes a surgeon if you feel that that adhering to the 1/3 requirement might allow surgeons to reduce their surgical practice by such an extent that they will no longer be able to be productive members of the center. Generally, these kinds of changes to the additions to the operating agreement should be done in a way that there's at least a colorable argument that the reason you're doing it is not simply to divert money over to the more higher referring physicians. There should be a secondary reason for that, which we deal with. So I'm often asked the question, well, how do you determine at the onset of an ASC, how do you determine ownership percentages of potential investors if you cannot take into consideration the volume or value of their potential referrals? And how do you deal with a situation where there's been a dramatic shift in the referral patterns when you can't just easily force physicians to change their ownership percentages? One way that I've done it in the past, and I think that it's a defensible approach, is to have physicians voluntarily give up some percentage of their ownership. Voluntarily meaning you haven't threatened termination, you've they just, in order to keep everybody happy, they're willing to sell at fair market value their units over to other folks, other people. That avoids a situation where the center is syndicating shares based upon referrals. It's a voluntary transaction between two or more surgeons, and it's done at fair market value. And I think it's done properly. It could be quite defensible. I mean, so the purpose of today, I'll stress, is not to give legal advice to people on this call, because I don't represent a good number of the folks on this call, but to give you some just description of kind of what I've seen and how I've handled certain situations. Another ounce of prevention, part 2, we'll call it, which is screening potential surgeon investors before they invest. You know, if you're starting a center from scratch, you have a lot of ability to, as I said before, to create documents that encourage the proper referral patterns, but also you have the ability to pick and choose who you want at that center. To me, that's the most important decision you can make. The physicians are your customers, okay? They're not just owners, they're customers of the center. The patients are not really customers. They don't choose necessarily where they're going to go. The surgeons choose. The patients are patients, obviously nothing more important than that, but they're really not your customers. They're really, the surgeons are your customers. And you want the best. You want surgeons who are not only are very good quality. You should do extensive credentialing to make sure that you're bringing on people that are very, very good. I've seen terrible situations occur where you have very busy surgeons, everybody wants them on board, and then they have huge malpractice cases that ultimately result in financial liability for the center that doesn't justify bringing that person on. So you need to do credentialing, get a copy of their malpractice history, find out if there's ever been investigations against them, and avoid bringing people on that aren't the best. The other thing is you're allowed to do some financial due diligence, and every center does. You can request, a surgeon's case volume by CPT code, their payer mix. You can get a sense as to whether they're going to be valuable to the center. And you can ask for supporting documentation. I have seen, unfortunately, many instances where surgeons give information that is not borne out by the ultimate performance of that surgeon. You also want to make sure that the surgeons don't own competing ASCs. I really think that if a surgeon has an ownership interest in another ASC that's within a radius that is likely to potentially divert patients to the other ASC, that you should be very wary about offering ownership to that individual. And after all, it might violate the non-compete if you did. I've seen situations where the center will carve out exceptions. Sometimes that works out. Many times it does not work out. They may be very disenchanted with this other center and promise that they're going to bring their cases to you, but all of a sudden, they have a rekindled relationship with the other center for one reason or another, and their referrals start to dry up. So you really want surgeons that are totally committed as business owners to the center. Keep in mind that the surgeons that buy in on day one will buy in typically at the lowest price because they're buying in before the center has any volume. You have to charge fair market value for the units under the Anti-Kickback Statute. If you charge less than fair market value, you're giving remuneration to the surgeons in exchange for referrals, which is a kickback. A lot of if you could bring doctors in without charging them fair market value, I'm sure many centers would be happy to pay high volume surgeons for the privilege of giving them shares. They'd be happy to pay them for it, but that's not legal. You have to charge fair market value, and fair market value is typically never lower than it is, before you even start seeing patients, when there's no EBITDA, there's no earnings. It's just a raw center, maybe just license, or maybe just the ability to obtain a license without even a fitted out center. You can sell units at a very low price, which can be very appealing to high volume surgeons who don't want to spend a lot of money for units and are maybe being offered very, very low deals, maybe even inappropriate deals from competing centers who want them. A very good surgeon is like a rock star who's sought after by every center available, and many centers are not very scrupulous when it comes to how they make offerings, and it can be difficult to compete with them because if you're trying to do the right thing and abide by the law, you have to charge fair market value. My recommendation to any client that is worried about this is build the best possible center, lure the best surgeons who are honest by providing them with a great facility, great support staff, and other great partners who are going to generate a lot of money. And if that doesn't bring people over, then move on to the next candidate, honestly. You know, let's go to the next slide. Michelle, you want to talk about this slide?
So once you've, as Dan said, lured them in and you have new physician members of your surgery center, it's important to make sure that you monitor and make sure that they don't become or start to exhibit problems. And there's several ways to identify these problem physicians and to get ahead of it and to make sure that the center as a whole is covered should there be any exposure or liability from a physician's actions or omissions. At the very beginning of membership and giving privileges, there's credentialing. It's very easy to take the credentialing seriously at the outset, asking for information, documenting, and making sure that these physicians are people who you want to give privileges to. However, it's important to make sure that the credentialing and re-credentialing process is also followed. It's important to maintain assurances from these physicians that their privileges have not changed, that that the scope of their practice has not changed, that they're not coming into the center and performing procedures outside of what they originally indicated they would or for which privileges they've been given. It's important to make sure, especially that there is proper malpractice in place, professional liability insurance. You want to make sure that you have received information, documented the information, and performed some due diligence, a decent amount of due diligence, so that if there's ever a situation where you have to look back, the center can say, we received this information, we investigated it, and we did our best to make sure that everything was proper. There was I would like to point out that while this might not be something that you consider, there was a case several years ago where a patient sued a physician as well as the center where the procedure was performed, because as it turned out, the physician did not have the proper malpractice insurance in place. And this case was litigated for several years. It went from the trial level all the way up to the highest court, the Supreme Court of New Jersey. And ultimately, the physician was not held liable financially because the courts determined that the Board of Medical Examiners would handle the situation. But there was exposure to the center on the theory that the center did not take the appropriate steps to make sure that their physicians performing procedures there did maintain the required or the mandated malpractice that is required of New Jersey. So the key takeaway of that is document, investigate, do your due diligence, and try your very best to set up your center to avoid potential liability or exposure. Requesting that a physician, as Dan said earlier, affirm certain things, affirm the compliance with the 1/3 requirement, affirm that they have not been subject to disciplinary actions at other places where they might have privileges, affirm that they are still, that there's no issues or limits to their physician license, their medical license. And again, ensure them, make them affirm that they have the proper required insurance in place. It's also important to incorporate behavioral standards into your documents so that you have a guideline by which everybody understands how they should act, how they're expected to act, and what those issues would be should they not follow that course. And while you can't generally indicate every single issue that a practitioner should follow, a member should follow, there should definitely be guidelines. They can be somewhat broad so that they incorporate different scenarios. But having them identified, for example, in your operating agreements and in your policies and procedures, it allows the center to maintain the standards that they want, identify these potential problem physicians, and have a basis for which to deal with it. There could be a situation where a member, is not following the guidelines of the operating agreements. And then how do you go about taking into account the fact that they are an owner? While having a identification of what is expected of these physician members and the ability to terminate their membership in the event that they are deviating from those standards. Again, having everything out there provides notice to the members of what is expected of them and allows the center to take action should they not follow those. What we would generally recommend is a situation where there is a provision for termination with an opportunity to cure. It serves a few purposes. First of all, it identifies to the physician what actions they have not followed or what actions they might have violated. And it gives them an opportunity to correct it to the extent that it can be corrected, and basically gives the center the ability to say, should the physician not actually correct their behavior, we gave you an opportunity to cure, we told you what the issue was, and you did not cure it, and therefore we are terminating your membership. Easier said than done, but certainly having this opportunity to state that you did give them the opportunity, hopefully gives the member the understanding of how important it is to follow the operating agreement, as well as gives them an opportunity to correct that behavior. And then as to the center, in the event the physician does not correct their behavior, they've identified that we gave you an opportunity to cure it, you did not, and you knew what the ramifications were. And should there be a claim afterwards of wrongful termination of membership or some other claim, the center has the backup of what they did to allow this physician to correct the behavior and hopefully serve as a way to limit or avoid liability in that regard. With regard to the actual physician procedures and the propriety of them, have a practice by which there is a random audit of the medical records. Make sure that the surgeons understand that their conduct and their procedures are going to be subject to a random review. It allows the center to confirm the medical necessity and that the appropriate clinical judgment was rendered in this particular case. A means of checks and balances and the ability for, again, problem physicians to be called out and hopefully change their ways. But again, hopefully a good potential to limit liability should there be something down the road as a result of these physicians' actions. There's also another scenario that we often guide our clients on, and that has to do with the concept of harassment, intimidation, bullying, which is three big words that have been coming around over the last several years. And what we have found from these types of situations is that having a policy in place, a written policy that is identifiable and provided to the staff, employees, physicians, members, everybody understanding that the center as a practice as a whole does not permit harassment, intimidation, and bullying. One of the first steps that an attorney would ask a center or a practice if there was ever a lawsuit is, did you have a policy in place? If you are answering the question no, you have absolutely done a disservice to your center, because even having a policy in place could be a very strong defense, or at least a very strong way of limiting the liability. You can almost never actually determine how somebody would act in a situation, but having a policy in place that you can turn to and say, our policy provided for A, B, and C, might be in a situation where somebody deviates from that, but at least knowing that there was something in play does help the practice. Take complaints seriously. Not every complaint is going to be valid. Not every complaint is going to maybe make sense, but it's important to identify to the people making complaints that it is something that the practice, the center will take into consideration. Document the complaint, document what you do to investigate the complaint. Hindsight's always 20/20, but having something to actually refer back to about what steps the center took to investigate and deal with these issues, again, is a significant way to defend or hopefully limit or avoid liability should there be a claim later on. He said this, she said that. It's very easy to have those statements, but if there at least is something to document what took place, it becomes, in my mind, more credible. And keep these complaints as confidential as you can. Identify one or more people to be the people who take and investigate, and just make sure it's not the person who's the ultimate, the highest supervisor, because in that regard, sometimes could be intimidation in itself. So there are always a handful or more of problems that can't be identified at the beginning, but by having structure, having written guidelines and oversight and documentation is certainly very big steps in doing your best to protect the center.
Thank you, Michelle. I'll just add, one of the interesting factors that I've come across with centers and problem physicians is that, your typical employee manual governs the behavior of your employees and protects your employees, but your surgeons are not employees, they're owners. So whether they are protected by a typical off-the-shelf employee manual is you should not assume is the case. There may be a way to tie them in, and your employee manuals should recognize that ASCs are not typical businesses because of that difference between the surgeon's role and an employee's role. This is our last slide, I believe, and I don't have too much to add to what we've said, but sometimes you put everything in place, you have the right legal documents, you have the right processes, you've chosen the right surgeons, you think, and you still have to react to problems. And Michelle, I think, went through some of those reactions. Changing physician behavior, if you have a difficult physician, can be very challenging, but it should be done. It should be done in a very public way, in a way that everybody knows. If the physician is doing something wrong, everybody knows. You're taking remedial measures, you're documenting it. Restructuring ownership, we talked a little bit about that. That can be challenging because of regulatory issues, but it is something that can be possible, can be done under certain circumstances. And ultimately, terminating members. Terminations can take place because someone violated the operating agreement, because someone engaged in behavior or malpractice or something that jeopardizes the center, or because we had one instance where a surgeon who clearly the center that wanted to terminate this particular surgeon, but didn't have a very good reason to do so other than lack of volume, discovered that the surgeon had misrepresented his the number of malpractice cases in his annual credentialing application. And the center is using that as a mechanism to terminate the physician, because they were essentially looking for something. So this is a complicated area, and I hope that some of the things we talked about today were helpful. And I don't know if there are any questions, but happy to answer any.
Yeah. So there was one question that was posed that I would like to respond to. The question has to do with if a physician has a complaint against him for physical violence at a hospital, but there's been no evidence of improper behavior at the surgery center, what should the surgery center do? And I think that's a great question. And it is a little bit of a catch-22, because it's as far as just taking the question at its face value, if there has been no determination at the hospital level, because I'm certain they would be doing their own investigation, you're still dealing with an allegation. So you want to be certain not to assume or make your own conclusions as to what the hospital complaint might relate to. But in the same regard, knowing that it exists, you do have to consider how to deal with it at the ASC level. And what I would suggest is if the practitioner has already told you about this complaint against him or her, I would take steps to make sure that depending on what that complaint revolves around, there are safeguards in place. And just by one example, if there's, I guess in this example, it's a physical abuse against a nurse, obviously I would try to have other people around and make sure that there are as many safeguards in place as you can at the surgery center to avoid similar complaints.
And I have a question, Michelle. First of all, how much of a right does the center have to conduct its own investigation of something that's alleged at the hospital? And does the surgeon, as an owner of the center, have an obligation to cooperate with that investigation?
So I feel that the center does have the ability and the right to conduct its own investigation because they are aware of an allegation. It's a serious allegation, and should this physician engage in similar behavior or be accused of similar behavior at the surgery center, you're now involved in a scenario where you had notice of one complaint and you've essentially kind of allowed it to potentially happen here. The center can do due diligence. I would be very careful about, again, assuming facts, but you can do your own investigation and, discuss it with the physician. And the physician, as an owner, certainly has an obligation to comply because as a whole, his or her actions could certainly affect all the members and the center itself.
Are there any other questions that we have? I think there's one more question. It was an OSHA question. Okay. I think that's it. Thank you, everybody.